Many of you have recently expressed concerns about the risks of deportation, especially with the possibility of stricter immigration policies if a Trump administration returns to power. This is a valid concern for millions of immigrants in the U.S., and it's important to explore what different groups might face, what risks are real, and how to prepare. Let's break it down in detail. Before moving forward, consider subscribing to our channel for the latest U.S. immigration updates, and if you find this video helpful, don't forget to give it a thumbs up. Asylum seekers are among the most vulnerable under shifting immigration policies. Within this group, there are two key categories to consider. The first includes individuals currently in deportation proceedings, those who already have an active immigration court case and a scheduled hearing. The stakes are high because if their asylum claim is denied in court, they will receive a deportation order, making them a high-priority target for removal by Immigration and Customs Enforcement, ICE. However, receiving this order does not necessarily mean immediate deportation, as enforcement depends on ICE's actions. The second category consists of those with pending affirmative asylum applications, individuals who filed their claims directly with U.S. Citizenship and Immigration Services, USCIS, and are still awaiting a decision. Many have been waiting for years due to massive backlogs, with cases pending for 6, 8, or even 10 years. If a Trump administration reinstates the last-in, first-out processing policy, newly filed cases may be prioritized, causing even longer delays for older cases. While this approach aims to deter fraudulent claims by fast-tracking decisions, it could create greater uncertainty for those already waiting. If an application is ultimately denied, the individual may be referred to immigration court, facing the same risks as those already in deportation proceedings. Permanent residents or green card holders generally have a stable legal status, but there are specific exceptions that could put them at risk. One major concern is criminal convictions. Certain crimes, including aggravated felonies and offenses involving moral turpitude, can make a green card holder deportable. Even seemingly minor offenses, such as shoplifting or a DUI, can carry severe immigration consequences depending on the details of the case. Anyone arrested or charged with a crime should consult an immigration attorney immediately to assess potential risks to their status. Conditional permanent residents also face challenges, particularly if they fail to remove conditions on their residency. Those who obtained conditional green cards through marriage, for instance, must properly file Form I-751 to remove these conditions. If the process is not completed on time or correctly, their residency may be revoked, putting them at risk of removal. Additionally, fraud or misrepresentation during the green card process, such as providing false information or engaging in a sham marriage, can result in permanent resident status being revoked. Green card holders who travel abroad should also be mindful of prolonged absences. Staying outside the U.S. for more than 6 months could lead to scrutiny upon re-entry, with some facing accusations of abandoning their residency. During Trump's first term, some green card holders from certain countries encountered entry difficulties under the travel ban, though courts ultimately reaffirmed their rights to return to the U.S. U.S. citizens hold the highest level of security under immigration laws, and their status is generally protected. However, in extremely rare cases, citizenship can come under scrutiny, particularly in instances of fraud. The main concern is the possibility of denaturalization, which occurs when it is discovered that an individual obtained U.S. citizenship fraudulently. This may include providing false information during the naturalization process, hiding a criminal record, or misrepresenting residency requirements. If someone is denaturalized, their U.S. citizenship is revoked, and they revert to their prior legal status. If they were previously a lawful permanent resident, they may regain that status, but if they had no legal status or obtained their green card fraudulently, they could become undocumented and subject to removal. Denaturalization is extremely rare and requires extensive legal action initiated by the government. It cannot occur arbitrarily or without due process. Anyone facing denaturalization proceedings will receive official notice and have ample time to prepare a defense. The case will proceed through the courts, allowing the individual to contest the charges before a final decision is made. While denaturalization is a minimal risk for most, It underscores the importance of adhering to legal processes and providing accurate information when applying for immigration benefits. For the vast majority of naturalized citizens, their status remains permanent and secure, granting them full rights and protections under U.S. law. To protect yourself, start by understanding your current immigration status and the specific risks that apply to your situation. If you are uncertain, consider taking the following steps. Consulting an immigration attorney is highly recommended, whether you are applying for asylum, renewing a green card, or dealing with a criminal issue, as professional legal advice can be invaluable. Keeping documentation of your stay in the U.S. is essential, including leases, utility bills, employment records, and tax returns, as these can serve as proof of your presence if needed. Staying informed about immigration policies is equally important, as regulations can change quickly, and staying updated on new developments could help you navigate potential challenges. Thank you.